appeal, O'Connor and the proprietors' Strata plan.
Yes, Mr. Tom.
May it please your Lordships, I appear on behalf of the appellants, my learned friend Mr Wilson, who is both a member of the English Bar and the Turks and Caicos Bar. The respondents are represented by my learned friends Mr Featherstone Hall, Mr Griffiths, who likewise is a member of the Turks and Caicos Bar as well as of the English Bar, and Mr Dray.
Thank you.
Well, Lords, the respondent's case in substance, as we understand it, is that the Pinnacle is and always was intended to be a residential apartment complex, and that my clients are deliberately carrying on a commercial undertaking to the understandable annoyance of others. And we say that that puts it too high for a number of reasons, which we'll develop as briefly as we can later on. We do, of course, acknowledge that before the decision of the Court of Appeal, my clients were letting their unit for periods of less than a month, as they understood they were entitled to do under the law of the Turks and Caicos Islands, and as they believed they would be allowed to do from before the time of their purchase. It's right, of course, that I should immediately acknowledge that there was an estoppel case run at the trial, and it failed. But it didn't fail because the judge didn't believe that my clients were given certain assurances. It failed because those assurances were given by the developer and by his agent, and couldn't be taken to be binding as far as the subsequent executive committee, once the Pinnacle had been fully developed and sold, were concerned. And this is, the Pinnacle being on Providence Isles, is on an island which is full of holiday use. And in our respectful submission, when one looks at the prism of residential apartment block through which the respondent invites you to look at the bylaws, that is an inaccurate and distorting prism. I don't say that, of course, in any pejorative sense as far as my learned friends are concerned, but as far as the validity of the argument is concerned. 2 points in particular. First of all, factually, when we look a little bit at the marketing documents, the position was much more blurred than the respondent's submissions suggest. And secondly, the bylaws in this case are not the sort of bylaws one would expect for purely residential block. There is two uses. First of all, the owner, and secondly, accommodation of his guests and visitors, suggesting we would submit that they can go in his absence. And indeed, with a second home, as many of these apartments are, many people prefer, or like, to permit others to occupy their second home in their absence. So we say the Pinnacle was always going to have some residential occupiers and some who would be holiday makers, and in that situation, conflict is bound to occur. I'm sure that some of your Lordships have had the experience I have of appearing in West Indian jurisdictions, and if you're waiting to go to court at 9:30 the next morning and the band strike up in the pool bar, it's quite an uncomfortable experience, but it is the inevitable result of being on a holiday island. At the centre of this case is the issue whether the proviso to bylaw 7.1.9, which limits leasing to a term of 1 month, is or purports to be a restriction on the leasing of the unit. And that central question is quite a short question of construction of the bylaws and the ordinance. And in our submission, a restriction on the term of the lease is plainly a restriction on leasing. Some potential durations of the lease that my clients could grant are utterly excluded and prohibited. But we would submit also that that conclusion is reinforced by a consideration of what the bylaws and ordinance permit apart from the disputed proviso and the purpose of a prohibition on restricting leasing. A word on the issues. Those have narrowed during the exchange of written cases. The central issue is, as I have identified it, are the O'Connors entitled to let for a period of less than a month? And since the bylaws say they can't, clearly that comes down to the impact of Section 24 of the Ordinance on bylaw 7.1.9. The respondent's formulation takes words from issue 2 and inserts them into issue 1. As we see it, issue 2 has now gone, so those words are being resurrected. We don't take formal objection to that. Of course, if they want to reformulate their central issue, then they're free to do so. But issue 2 was directed at the question whether licenses granted by the O'Connors were caught at all by the bylaws, and we said in our case that we weren't pressing that ground. We could have been clearer, but it was intended to indicate that we don't pursue that ground. Issue 3, as originally formulated, was whether the arrangements between the O'Connors and their occupiers were leases or licenses. The judge held that they were leases. The respondent have now conceded that the arrangements amounted to leases, so that issue doesn't arise. The remaining issues then are costs, and in particular, if the O'Connors succeed, can they be relieved from paying a contribution to enable the respondents to pay their costs, and a contribution to the respondents' costs of ex hypothesi unsuccessful litigation. And the respondents say that there is no jurisdiction for any court to make such a relieving order in the Turks and Caicos. We've raised the issue of leave to appeal. We're very much in Lordship's hands on that. We probably don't need to say anything about it other than what's in the skeleton. But in our submission, this was plainly an as-of-right appeal. And it would be helpful if your Lordships are of that view, if your Lordships could say something, and perhaps in future the number of cases that have to come here for permission could be reduced. On the principal issue, our submission in a nutshell is this. A strata lot can be leased in the same manner as registered land. The registered land, as it applies to an owner or to a chargee exercising a power of sale, imposes no minimum term as far as leases are concerned. The substance of the bylaws in our submission is that there is a minimum term of 1 month, and in our submission, as a matter of logic, that must therefore be a restriction on leasing. And we do pray and aid that the duration of a tenancy is one of its essential elements. A lease is a demise of a defined space for a defined period. And, my Lord, in those circumstances, we say that is the central resolution of the central issue. And I'll now turn to develop in the next, a little under 2 hours now, the appellant's case. I will not take your Lordships, obviously, to every part of the written case. That's not because I don't rely upon them, other than where we indicate otherwise.
We've read it all. We've read it.
Yes, exactly. And so my reading it again might serve to irritate, but it won't serve to elucidate, and so I'm not going to do it. I'll take your Lordships to as few of the authorities as I reasonably can, and try very hard not to get bogged down in them, because that's where I can see myself possibly getting into trouble. I will try to deal as far as we can with the respondent's case in my opening rather than leaving it for reply. And I anticipate that I should be able to finish by the stroke of 1 o'clock. Well, so moving on in the appellant's case to paragraph 15 of page 478. We are criticised, I think, for part of this argument, but one of the matters we thought would be helpful to consider is what is the purpose of section 20 sub 4? Why are the parties not simply free to restrict leasing or any other kind of devolution if they choose to do so? And in our submission, the purpose plainly is to ensure that the strata title unit is freely marketable.
Why would a restriction on short-term lets make it any less freely marketable. There are potentially 2 points. One is you might want to market it as a suitable place for holiday lets. It might be worth more on that basis. But I don't think you're suggesting that that's the object of Section 20 sub 4. If the object is not to, so to speak, gum up the title by having a tenant in possession, if he's only in possession for less than a month, what's it matter?
Well, we look at it the other way, and that is that it is the unit owner who should not be restricted from leasing. It's not his tenants who are so much being protected. Now, in some circumstances, a restriction on short-term, on a particular duration of term, may not matter terribly much. In others, it might be terribly important. We raised the question of the hurricane. If you want to try and maximize the value of the land, then you may wish to or need to indulge in short-term letting.
So you say this is, the purpose of this is to maximise the commercial value of the property.
It is to ensure that the strata unit owner has all the rights that a freeholder would expect to have. And that includes the right to exploit his property in a way which he thinks fit. Now, it may be that Section 24 hits a larger target than was the minimum necessary for that. But the language, no restriction on leasing, I paraphrase, in our respectful submission isn't no restriction on some leasing, it is not to restrict leasing.
But all bylaws, surely, are liable to restrict the otherwise unrestricted rights that a freeholder would have.
Yes, and what Section 24 does is it draws a line in the sand and says this is where you can't restrict. And we entirely accept that when it comes to, say, user, if you say, well, you cannot use for business purposes, then that will eliminate some potential tenants of the property. But when it comes to saying you cannot have a lease of a certain duration, in our respectful submission, as a matter of language as well as logic, that is a restriction on leasing. In our submission, it is illegitimate under Section 24. Now, and one of the points that's made in Dunlop is, oh, well, it's not a restriction on leasing because that was not strictly a duration one, because you can always lease within the bylaws. But if that's right, then you can never have a restrictive bylaw, because whatever restriction there is on leasing in the bylaws, you can always comply with it. The point of Section 24 is to deprive of effect those bylaws which restrict leasing and the other kinds of devolution that are set out in the bylaw.
You could have a bylaw saying you shall not use for occupancies of less than a month, could you?
I don't think that would work, because it would be so nakedly a restriction on leasing.
Well, not necessarily. It's a restriction on use. You know, the purpose of the bylaw is to restrict a certain type of use which is thought to be undesirable. So, I mean, that's what this purpose is. And if that's expressed as a restriction on occupancies of less than a month, why is that? What's the problem with that? I mean, I agree that's not what it says, but...
There must come a point where a restriction on use becomes so all-pervasive that it actually amounts to a restriction on devolution.
Can I ask you, if bylaw 7.1.9 had only contained the first sentence,
yes,
would that amount to a restriction on leasing contrary to Section 20 sub 4?
The reason we would submit that it wouldn't would be that bylaw 7.1.16 provides that we are still entitled to lease.
So apart from that, you would say that if there was a restriction on business use, that was a restriction on leasing.
No. I wouldn't go that far, but as I understand my learned friend's argument, he says 7.1.9 means no letting the first sentence means no letting whatever. And if that's what they're saying, then I would say that is a restriction on leasing. If I've misunderstood his position, so be it. But if 7.1.9 first sentence means under no circumstances can this property be let, then in our respectful submission that is a restriction on leasing, even though not worded as such. And my Lord, there we say we look to the substance and not the form, and that would be the substance.
So, I see. So your submission is that in substance, any restriction on, or a restriction on use other than as a private residence is a restriction on leasing.
My submission is that anything which has the effect of directly precluding a lease is a restriction on leasing. And a restriction on duration is purports to have that effect, and therefore by Section 24 it cannot operate. And so if there is a total prohibition, whether it's dealt with by way of a purported restriction on use, a total prohibition of leasing, in our respectful submission, that is an effect which Section 24 says the bylaw cannot carry out.
What if it said not to be used for holiday purposes otherwise than by the proprietor or his guests and visitors? Would that be a restriction on leasing?
If it were not to use for holiday purposes, then that would be, I would accept, a user restriction. Nobody on this island would develop a block and put it onto the Strata titled market with that bylaw in it, because that's not why people come to the Turks and Caicos. They come to the Turks and Caicos for holidays. Units on the Pinnacle are not all occupied by people who live and work on the island.
No,
What about not to be used other than by the proprietor for holiday purposes,
or his guests and visitors.
or his guests and visitors?
Had that been the bylaw that was put in place, I can see that that could be argued to be a user restriction only. But again, that wasn't the way that the bylaws were drafted, no doubt for very sound commercial reasons, because many second homeowners like to recoup the costs of their development by letting out from time to time, and it was always intended in the Pinnacle that that should be possible. The only question was, is the 1 month restriction, which the bylaws seek to impose, a valid restriction or an invalid one?
Well, it can't have been intended if it was clear that the rights were subject to bylaws which contained this restriction, unless you're suggesting that everybody proceeded on the basis that such bylaws could be ignored as they were void.
I'm very sorry, I didn't hear that.
Well, it can't have been intended that it should be freely lettable for holiday purposes in view of the fact that the flat was purchased knowing that the bylaws applied and contained this restriction, unless you are submitting that everybody buys and sells these flats on the basis that restrictions on holiday letting can be ignored because they're void. Is that your submission?
No, my lord, it's not my position. It's not my position that the restriction is void, rather that it cannot operate by virtue of the statute. That's the first point. The second point is, in our respectful submission, Section 24 overrides the bylaws. That's what it's there to do. It's not necessary for everybody to have been aware of that. If the ordinance overrides the bylaws, it overrides the bylaws. And of course, we now see an issue between my learned friends and us on this side of the court as to what the effect of Section 24 would be in terms of the severance of the relevant provisions. I'll come to that in a moment.
Mr. Tom, you've agreed that the bylaws regulating use can, in certain circumstances, inhibit leasing. In particular, inhibit leasing to particular people, for example. So what is the distinction you draw between that sort of use provision which invades dealings and the one that we're concerned with in this case?
The difference between having an indirect effect and having a direct effect. Under the Strata Titles Ordinance and the Land Registration Ordinance, my clients as strata lot owners have a right to lease with no minimum period. And what the bylaws purport to do is to exclude a range of potential durations. And we say that is a direct removal of part of the right of leasing, and therefore it is a restriction on leasing. My Lord, the other thing that Section 24 also does is it prevents the modification or destruction of easements which are implied or created by the ordinance. And I can tell you, Lordship, I don't think we need to go to look at it, that Section 19 of the ordinance creates and implies certain easements between the various lot owners, such as support and passages of services and media and shelter, and any ancillary rights necessary to make them effective. My Lord, we've touched on the points that we make in page 481 in our written case, which are criticised by my learned friends as being public policy points which were not pleaded, including the fact that one of the mortgagee's chargee's remedies after a receiver who's been appointed is a statutory power of leasing. We're not taking a point about finance, as it's clear from the evidence. My clients didn't buy the flat with finance. But we do submit that the purpose of Section 24 is to preserve intact the ability to carry on dealings. And that's why we refer to one of the methods of leasing which is available under the Registered Land Ordinance. It's not a new point in our submission. It's simply a consideration of related legislation for the purposes of identifying what the purpose of Section 24 is. And it's entirely true that it wasn't addressed below, but in our submission that's no reason why we shouldn't address it now. My Lord, moving on then to page 481, it's our submission that what one should look at is the substance and not the form. My learned friends say in their written case, well, it's no part of their case that you should be looking at the form, and I take it, therefore, that it's not necessary for me to cite any of the authorities that appeared in that part of our written case, and I shan't do so. I would like to say a few words about the respondent's case as we understand it in relation to bylaws 7.1.9 and 7.1.16. And the first point is this, that one sees in 7.1.9 the second sentence starting with the words, notwithstanding the foregoing, and as I understand it, the respondents seek to pray those words in aid in our respectful submission, that part which says, notwithstanding the foregoing, the proprietor may rent out his residential strata lot from time to time, may be nothing more than an acceptance by the draftsman that Section 24 provides or prevents the inhibition of that right. If all that had been imposed by the bylaws thereafter was a use restriction, then doubtless we wouldn't be here. But it's at that point that a duration restriction goes in, that in our submission the draftsman essentially got things wrong and fell foul of Section 24. And as we understand it, the assertion is, well, if the second sentence of bylaw 7.1.9 is omitted, then the restriction to private residence and accommodation of guests and visitors means that underletting is completely prohibited. That gives no value to the reference to letting in 7.1.16. And for other purposes, I'll take your lordship to a few of the references. The bylaws are sprinkled with references to the tenants of a strata lot proprietor. For example, the Strata Corporation is entitled to intercept rents from them and things like that. So,
what's the difference between renting and leasing in paragraph 16?
Bad draftsmanship, I would submit, my lord. I don't think there's intended to be any difference.
I mean, in law, I'm not sure what, I mean, there probably isn't a difference, but in sort of ordinary thinking, there probably is a difference. I'm just surprised they use the two words, because they must have thought there was some...
Maybe they had in mind a license for money's worth.
Yeah.
But strictly speaking, a lease and a tenancy are the same thing, and under both of them a rent is paid.
Yes, but it could be, as my lord says, I mean, renting might include licensing.
Yes. Well, it may have been an attempt to draw the matter that wide.
As you say, not very cleverly done.
The more one looks at 7.1.9 and 7.1.16, the more difficult one often finds, well, I suppose the more difficult they seem to be, but then one often finds that, and I suppose it's fair to say that in the course of this case, the scrutiny that has been applied to them is many hours the time taken to draft them. And then, again, that's not unusual.
Well, it doesn't really impinge on your argument anyway, does it? The distinction between renting or leasing, yeah.
It's no part of my argument.
Yeah.
Well, your submission is, as I understand it, that 716 is effectively a recognition of a general right to lease. And that would have no meaning if the right were cut down in the manner suggested under 7.9.
Yes.
I mean, the difficulty about that is that there's no inherent inconsistency between having a right to lease in principle and another provision saying, provided that it's not leased in such a way as to infringe the following user restrictions. For example, a restriction on business letting.
I accept they could do that, and I accept that if they had wanted to impose a wholly uneconomic restriction, such as you can't use this for a holiday or you can't use this for a second home, on the authorities, that would have been on the user side of the dividing line. But they didn't do that. They imposed a minimum term, and that in our submission they can't do.
But Mr. Tom, insofar as 16 talks about renting or leasing in accordance with these bylaws, that sends one back up to 9.
Yes.
What does 16? Why are we concerned with 16? I mean, it's all about 9, isn't it?
Lord, it is about 9, but if, as my learned friend submits, the second sentence of 9 disappears, then the reference to leasing in 7.1.16 16 still remains, and it of itself would entitle any...
Provided it didn't result in a use that was restricted by the first sentence of 9.
Well, quite. If all you've got is, if the basic user restriction is the first sentence of 9, which confines the use of the property, as I understand it, for the accommodation of the proprietor or his guests and visitors, and I think that means his guests and visitors, i.e. people who are visiting or being entertained by him there, then you appear to have a complete prohibition on letting it to someone else so that the tenant can use it as his accommodation. Forget holidays. I mean, a letting for, say, 10 years. And 716 doesn't save you, does it? Because that's only about business use. And a single letting for 10 years wouldn't be a letting in the course of business, probably.
It says not to use other than, not to use for purposes of business, other than letting the property.
Well, try out, cross out second sentence of 9, keep 16, and contemplate a 10-year, I think everybody would call it a lease rather than a letting, on a one-off basis to someone to use it as his private residence.
Well, in my respectful submission, when 16 accepts from the business, trade or business user restriction, periodic renting or leasing of the Strata lot in accordance with these bylaws, reading those two together, in our respectful submission, 9 does not, as it would if it stood alone, restrict the use to resident or accommodation of his own guests and visitors visiting him. It must then include guests and visitors, as guests and visitors, those who pay to lease the property from him. One can't take 7.1.9 by itself, assign it a meaning, and then try and cut down 7.1.16. They have to be read together. And with all the other indications that leasing is permitted, in our respectful submission, the reference in 16 to periodic renting or leasing can't be a reference to somebody taking it for 10 years as his own residence. The word periodic must have, in our submission, some value. And again, if that's what 7.1.9, if it stood by itself, well then that wouldn't have been this apartment block as it was marketed and sold. It doesn't stand by itself. The right to let was an integral part of the bargain that everybody had. And the issue is whether my client can let for 2 or 3 weeks instead of for a minimum of a month.
Yes.
Well, I'd like to look at a couple of the marketing documents, if we could. First of all, at page 258. This is a document called the Pinnacle on Grace Bay Rental Programme, which Mr. O'Connor Jr. said he discussed with the owners, the developer's agent. And they refer to the rental programme as unique to the market. The fundamental difference, they say, is that the management of the property falls under the domain of Pinnacle owners, not the developer and resort operator. The Pinnacle will not be available for daily or weekly rentals. A 1-month minimal rental will apply. This does not mean, however, that guests have to stay a month. They then say the introductory rates are competitive. And they go on to say in the second sentence of the next paragraph, owners who decide to rent in order to cover their association fees do so with minimal impact to their suite and the property. So, pausing there, the indication was that there's a 1 month minimum period, but the guest doesn't actually have to stay there. That's part of what I described as mixed messages.
Well, is it so mixed? If you let it for a month, it doesn't, whether or not you're in breach of the bylaw will not depend in the least on how much of that month the lessee spends there.
If you let for well, our submission would be that if you let for a month, then the fact that the tenant doesn't want to stay there for a month is neither here nor there. If you buy a bottle of wine in a restaurant intending to only drink half of it and leave the rest, it's still a perfectly good sale.
Sorry, what's the point you're making?
The point is twofold. First of all, the clear understanding that people would be letting their units in order to cover their costs. And secondly, that you could let for a month to somebody who would only occupy for less than a month.
Provided you let for a minimum period which corresponded to the bylaw. I don't quite see why this helps you.
Well, certainly the way the property is being marketed is that you can have an occupier to stay less than the minimum period in the bylaws, providing that the tenancy lasts.
That's inherent in the thing. I mean, all it's saying, I presume, is that you've got to rent it out for at least a month.
Yes.
Whether anyone stays there is neither here nor there, of course.
Mr. Tom, what are you saying is your construction of that slightly Delphic second sentence? This does not mean that guests have to stay a month. How is it taken on your side?
They understood that they could let for less than a month, but not more than 12 times a year. That's in Mr. O'Connor Jr.'s witness statement. That was the explanation that the agents gave to him of this document. I can take your lordship to that. It's at page 183 in the record.
Well, what it surely means is that you can let, if you've got a potential tenant who comes forward and says, I only want to spend a fortnight there, you can say to him, well, we'll only charge you for a fortnight, but you've got to take it, you've got to have exclusive possession for a month. That's consistent with the bylaw. What's the difficulty?
Well, two points, really. First of all, if I can let for somebody for a month and they're only going to stay there for 2 weeks, have you then got exactly the sort of unsatisfactory person that I'm supposed to be foisting on the pinnacle anyway, somebody who only wants a 2 weeks occupancy, who apparently is so different in kind from somebody who's prepared to take a lease for a month? It goes to the whole point of the...
We're not arguing about whether this is well drafted or not. It's clearly not. So clearly it may give rise to anomalies, but that doesn't really help.
Yes.
But it may not be totally effective in restricting holiday use. It probably won't be totally effective, but it may still have some use, and we're not actually concerned with how useful this is, but with what it means.
This I referred to for what I described as the mixed messages in terms of the marketing, and that the prism that you're invited to look through is that this is a purely residential apartment block. And in our respectful submission, whatever the meaning of the second sentence is, this clearly is not a purely residential block. Now, the Byrne case in Australia was a purely residential block with use restricted to permanent residents. I think the definition that finally fixed upon by the court was sole or usual abode. We are a long way away. But what Mr. O'Connor Jr. understood from the developer's agent was that there wouldn't be nightly rentals, there'd be a 1 to 2 week minimum, but there couldn't be more than 12 a year. And that was the significance of the reference to month. And if I could take your lordships to an email which was referred to by the judge in her judgment, which is at page 267 in the record. Where this is an email by Mr. Manuel, who's the agent of the landlords, to Ms. McCann, who's one of the witnesses on behalf of the Strata Corporation. And she's evidently just viewed the apartment, and he asks how she likes it. And then he says, after sending the bylaws and draft agreement, there's no rental management agreement because the Pinnacle will not be doing rentals for owners. Owners are free to choose their own property manager, with the reminder that there'll be a 1 month minimum rental period, i.e. no more than 12 rentals per year. The judge took it, and in my respectful submission, rightly, that that was taken as some comfort, that the key thing was no more than 12 rentals per year. And that, in fact, was consistent with what Mr. O'Connor had said he understood from Mr. Manuel, and that factually supported his case. And the judge is criticised for making an incorrect comment as a matter of law, but in our respectful submission, it's a perfectly reasonable comment as a matter of fact. When the respondent seeks to say that this is a residential block being disturbed by holidaymakers, is there really any substantial difference between somebody who takes a 2-week let and somebody who takes a 1-month let? The people who are really going to be upset by holidaymakers are going to be upset by holidaymakers however long they stay there, because of the inevitable conflict between people who want to go to bed early and get up the next morning and go to work, and people who are relaxing and having a good time and don't have to go to work in the morning.
I mean, you've got to draw a line somewhere. I mean, it's the problem we had in London, of course, again, of defining short-term lets, and they took 22 days, I think, in the GLC Act as being the difference between a short-term letting, which was to be excluded. I mean, you can say, what's the difference between 21 days and 23 days? None, but you've got to draw a line somewhere.
Yes. If you're going to draw a line, you have to draw a line, because our submission is that the line of duration is not the line you can draw. You have to find some other one. And the reason they couldn't find anything other than duration in this case is because they were trying to draw a line that couldn't be drawn between the interests of the different strata lot owners. They couldn't do a Byrne sort of user restriction, only permanent residents, because that would never have sold the development. And one suspects that the mixed messages that different people got from the developer may not have been entirely accidental. But anyway, I needn't develop that. My Lord, my learned friend's response to the argument on 7.1.9, if it's successful in terms of striking down the proviso that no lease could be granted for a period of less than a month, is to say, well, in that case, the whole of the second sentence has to go, because you can't sever the proviso from the first part of the sentence. And in our respectful submission, there are a number of reasons why that is an inappropriate resolution, if we are right on our primary submission, that the proviso purports to restrict leasing. First of all, if we go to page 227 in the record, bylaw 14.2 provides that in the event that one or more of the provisions contained in these bylaws shall be held for any reason to be illegal, invalid or unenforceable, such holding shall not affect any other provision hereof, and these bylaws shall be construed as if the said provision so held to be illegal, invalid or enforceable had not been contained herein. And in our submission, if we're right in our primary case under 7.1.9, the effect of section 20 sub 4 is that it cannot operate and therefore it is unenforceable, and therefore bylaw 14.2 in effect directs severance of that proviso and leaves us with the first part of, the second sentence of 7.1.9.
That assume that provision can apply to the two sentences separately.
And indeed, provision in my submission can apply simply to the proviso. It is a provision, it's a part of the document.
Yes,
Well, the whole point about the rule about severance is that it's concerned not to sever things which alter the effect of that which stays behind. So in applying 12.6, do we not have to work out what is the relevant provision? If the two things belong together and only make sense together, then they are a provision taken as a whole.
In my respectful submission, they are distinct. The first is the general, you may let. The second is a specific provision, but you cannot let for less than a month. And in our respectful submission, that is the objectionable part, which is struck down by section 20 sub 4. The statute itself provides that if it's a restriction, it can't have effect. In our respectful submission, 14.2 simply underlines that, and the severance is directed by the bylaws and in substance directed by the Act as well. Further, it's potentially a far-reaching point because, as I understand it, as far as the respondent is concerned, if we're right about 7.1.9 and they're right about severance, then nobody who has a flat in the Pinnacle can let it for any purpose whatsoever. So we would anticipate on this side of the court that there are quite a few of the residents who are currently supporting this litigation who would be pretty surprised to find that they have lost entirely the ability to let their properties for any period at all.
But then they would say the first sentence of 7.1.9 offends against section 24 because it's a disguised restraint on letting. If you can only use it for the proprietor and his guests and visitors, and guests is clearly used in contradistinction to tenants, for example, in further down in 7.1.9, then you just couldn't let it.
Well, we would say that if severance has the effect of taking out the whole of the second sentence, then it simply converts the first sentence, 7.1.9, into an inadmissible restriction on dealings, because it on my learned friend submissions, it precludes all letting for any period. And of course, if that's right, then they ask the Court of Appeal for the wrong injunction, because they should have got an injunction restraining my client for letting, not for letting for periods of less than a month. I don't want to dig too heavily into the detail of the Allnat case upon which my learned friend relies, but I would just say this. The comments of the Vice-Chancellor upon which he relies were expressly stated not to be part of the reasoning of the case because they were matters which had occurred to him which hadn't been ventilated in argument. So it's not the strongest kind of sheet anchor to trust the boat to. And secondly, and perhaps for these purposes one should just look at the Allnat case, which is in the bundle of authorities at volume 2, tab 16. The covenant is set out with the Vice-Chancellor's numbering at page 1359 in the bundle. And Lim 1 is an absolute covenant against dealings. Lim 2 then provides that when the tenant wants to assign or underlet, he has to make an offer to surrender, and there are some supplemental provisions about that. And 3, then if the landlords refuse such offer or don't accept it, 4, the tenant is at liberty to apply for consent. So that what happened in the case was that the tenant made the offer and the landlord accepted it. But the agreement arising from that acceptance was, by virtue of Section 38 of the Landlord and Tenant Act 1954, void, because it would have had the effect of preventing the tenant from making an application for a new tenancy. So the difficulty the tenant was in when it came, he was able to get out of the agreement to surrender, but when he then tried to say, well, look, I must now be entitled to have the benefit of the right to apply to assign, the events upon which that right arose, which were set out in Lim 3, either the landlord refuses the offer or he doesn't within the right time accept it, simply hadn't happened. So what was required by the tenant in the Allnat case was not merely exercising the blue pencil or the red pencil, it required wholesale rewriting of the covenant in order to give him a right which he didn't otherwise have. And in our respectful submission, the exercise which we submit that both the statute and the bylaw contemplate is simply the striking out of the offending words, starting with the word provided that. Well,
So you say that one is left with, at 9, not using the strata lot other than as a private residence, accommodation of guests and visitors, notwithstanding the foregoing, the proprietor may rent out from time to time.
Yes.
Full stop.
Yes.
I mean, the two sentences in there are really entirely inconsistent, aren't they, Mr. Tom?
My Lord, no, because they are reconcilable, because if they are left in that state, in my respectful submission, it follows that the strata lot owner can let his flat, but not to somebody who is going to use the flat for the purposes of a business, because then he would be permitting the lot to be used for the purposes of a business in breach of the first sentence of 7.1.9.
But why would that be a breach? I mean, if, notwithstanding the first sentence, you can let it out without restriction, why can't you let it for business?
Well, because you would still fall foul of the first sentence. If one reads them together.
I mean, the first sentence will limit you to the use by the proprietor, which is the person letting it out. So if he rents it out, it can be used by someone other than the proprietor.
You have to read guests as including tenants, don't you, to make your approach work?
Well, in my submission, not, because, and I'll come back to my Lord Cornwall's question in a moment. We don't have to read guests as tenants because reading the two together, you are allowed to let. But on the other hand, even then, you can't occupy for a business without going back to 7.1.16, where the consent of the Executive Committee is required. So,
But your consent is only required if you're not doing a periodic renting under these bylaws. So apparently, I mean, I don't understand how they're meant to work, because 16 only requires consent for a business if it's not a letting in accordance with these bylaws. If it's a letting in accordance with paragraph 9, then you don't need consent under 16.
well, my Lord, it may be that the bylaws fit together very badly. One might say, on my learned friend's submission, which is that 7.1.9, first sentence by itself prohibits business use. Why do you have an absolute prohibition of business use in the first sentence of 7.1.9 and a qualified prohibition of business use in 7.1.16? They're not, in my respectful submission, easy, but one has to interpret them with a degree of broad common sense, and our submission is that the better view is that if the proviso from 7.1.9 second sentence goes, nonetheless, one is still not entitled to let for the purposes of a business. One could let as a business, but not for the purposes of a business.
Well, I think perhaps we've exhausted this subject, have we?
Lord, yes. I'll move on. May we look briefly at some of the authorities on this subject from around the world? But I'll
mostly
take your lordship.
They're Australian authorities for the most part, aren't they?
They are Australian authorities. I think I should say from around the world of Australia, yes.
Right.
From the other part of it.
Is it right that all of the first instance authorities are effectively heard summarily and without argument? That was a suggestion that was being made in the respondent's printed case. Is that accepted?
Well, may I, in due course, take instructions? But I will come back to that. They are certainly a more summary procedure than a full trial. Could I outline briefly the way in which the authorities can be analysed? The first is that wherever there's a direct prohibition of duration in tribunal cases, that prohibition has always been struck down. The second is that where there have been user restrictions couched in terms of user, but which could be regarded as aligned with duration, though they needn't be wholly, then they have been upheld. Specifically Dunlop and the Byrne case. Thirdly, so far as some of the tribunal cases are concerned, there are indications that these are not isolated tribunal cases, but evidence of a settled practice. My Lord, with that preamble, could we please start with the Dunlop case, which is at tab 27 in volume 2. At page 1528 of the bundle, in paragraph 2, the bylaw is set out, and it says that the lots will be used only as resort accommodation and not for permanent residential accommodation.
So which court is deciding this?
I beg your lordship, pardon?
My Lord has asked which court. It's a tribunal, isn't it?
This is the Consumer Trader and Tenancy Tribunal. This is one of the cases this is the case which the Court of Appeal relied upon principally.
So this is effectively the equivalent of our first-tier tribunal, is it?
My Lord, as I understand it, yes.
And I thought it was an appeal from an adjudicator.
Yes, it's an adjudication, not a determination.
Certainly,
It's an adjudication
that appears
appeal.
from paragraph 1.
Yes, it is an appeal against an order by an adjudicator.
I mean, it's quite common to find strata cases being dealt with by adjudication.
Yes,
Same's true in British Columbia, for example, now.
yes.
Yeah.
But I mean, it has the same status as our first-tier tribunal, which also sits on occasions on appeal from
Yes, absolutely.
various sorts of decisions. Yeah.
Yes. In the way that the old Lands Tribunal used to sit on appeal from the LVT.
Right, well, now that we've established its provenance and position in the hierarchy, what do you take from it?
My Lord, it's a case that's cited against me, and it's a case upon which the Court of Appeal placed great reliance. So what I take from it is this. First of all, that's the bylaw, and I note that it doesn't, in terms, amount to a restriction on duration. The second point is in paragraph 15, page 1530. The tribunal member says this. He identifies the development consent, which refers to service departments. And he says, in my view, it's clear from the development consent that what was approved was a tourist resort where the dwellings would be service apartments. This can and should be distinguished from a regular residential strata scheme. And then paragraph 20, he refers to the reliance by the appellant on section 49(1) of the Act, which is in similar terms to section 24. And in 21, he says, I'm not satisfied that bylaw 7.3 is inconsistent with section 49(1) of the Act. Lot owners in the scheme may transfer, lease and mortgage their lot as long as that is in a manner consistent with the bylaw. He then cites from White and Bertali and he says, while the issue in White and Bertali concerned the power to make bylaws which didn't apply equally to all lots, I'm of the view that the decision of Sydney and Hamelina is also relevant. If an owner's corporation can make a bylaw restricting the use to which a lot can be put, which would have the effect, for example, of limiting the lot owner's choice of tenant, it can pass a bylaw which has the effect of limiting the length of tenancies where that is consistent with the development consent for the scheme. And that case was the fundamental basis of the Court of Appeal's decision. In our respectful submission, first of all, the case does not deal with a direct duration restriction, and in that respect, it is distinguishable. Secondly, while the learned judge's reasoning, or a tribunal member's reasoning, that there was no inconsistency with the section 49 of the relevant statute, because they could lease as long as that was in a manner consistent with the bylaw, in my respectful submission, cannot be a correct analysis of the position. If that's right, then no restriction could ever be struck down, because you could always comply with it in some form or another. And while I can see that you can say the part of section 49 which says you can't prohibit leasing is not engaged because some leases are permitted, there doesn't seem to have been any consideration in those short paragraphs of what meaning should be given to the word restrict in section 49 or indeed in section 24 here.
But as I understand it, the reasoning in paragraph 22 doesn't follow from your argument, because you accept that you can have a bylaw restricting the use to which a lot can be put, even though that incidentally does limit the range of potential of the market.
Yes.
Because that's not directly affecting leasing.
Yes.
So the reasoning there, your argument is not affected by that reasoning.
On the contrary, I say that reasoning as a ground for restricting duration is wrong. And this is the case upon which my clients effectively lost in the Court of Appeal, and it is our submission that the reasoning is unsound, and that if it is taken as justifying a bylaw setting either a minimum or maximum duration, then it was wrongly decided. The final point in it was that the tribunal member was concerned with the fact that the restriction went hand in hand with the development consent. That was the point that he was making at paragraphs 15 and 16. This was intended to be a development which was quite separate from a regular residential strata scheme. In that sense, one could even say, well, is this a restriction on lettings? Because all it's doing is repeating what the current planning position already is. The Court of Appeal picked up the words consistent with the development consent of the scheme. But of course, as your lordships will be aware from the parties' printed cases, there is no question of this development having any kind of development permission which has any bearing on the 1 month limitation. So that, I think, is as far as I need to go, so far as Dunlop is concerned. But the point we make there is simply that insofar as the Dunlop bylaws drew any strength or comfort from the fact that they were simply putting into effect the residential permission, which the short-term letting permission which had already been effected, then that is not the position in relation to this scheme. My Lord, I'll take your lordships to just one of the adjudications, the Bridgeport Apartments one. No, I'll take your lordships to Noosa Close, which is at tab 35 in volume 3.
Yes.
This is the Queensland Body Corporate and Community Management Commissioner dealing with an adjudication, and the bylaw is on the front page just above the bottom 2 lines.
Yes.
And the decision is that it's void. Then I can take your lordships to 1623, the last full paragraph on that page. And what he says there is that in the third sentence, it can be concluded from the above-mentioned dispute resolution decisions that adjudicators have consistently held that a resolution or a bylaw containing conditions regulating the periods for which a lot can be leased or let is invalid or void. And he then goes on to deal with this particular bylaw, and it says, this similarly seeks to regulate the period for which a lot can be leased or let. And there's no distinguishing factor. And so he concludes that it is void. And I do take comfort from the decision that it is adjudicators have consistently held, and in Bridgeport Apartments there was reference to numerous previous adjudications having supported the same view. My Lord, I'll take your lordships briefly to a case in the Grand Court of the Cayman Islands, the Foyth case, which is in tab 2 at 1540, tab 29, volume 2, tab 29.
Tab 39, did you say?
29.
29.
Yes?
This was a different nature of restriction. The requirement in the bylaws required owners of strata lots to let them through a central manager. That was the attractive feature in the rental management programme in relation to this property, was you didn't have to do that. The learned justice sets out the provisions of the law, and his conclusions are in paragraphs 12 and 13 on page 1546. The relevant statute wasn't as detailed in terms of what was struck down, but he concludes, having considered whether the word disposition in the registered land law included leases, and he concludes that it does. And then he says, in paragraph 13, the provision in section 21.4 of the Strata law, which prohibits the enactment of a bylaw restricting any dealing with a strata lot, appears in part 6, which bears the title Management and Administration. Section 21.1 of the Strata law contemplates that the control, management, administration, use and enjoyment of a strata lot will be regulated through bylaws. I accept that a restriction on leasing could be viewed as a component of a regulatory scheme for the control, use and enjoyment of the strata lot. On balance, though, I'm satisfied the textual analysis provided above dictates how the statute is construed. A bylaw may not prohibit or restrict a strata lot owner's right to rent or lease his unit. Consequently, he says, Clause 9, except 9.9 of the North and South Tower bylaws and Clause 8, except 8.9, are invalid. However, the sting in the tail as far as the occupiers was concerned was that provisions that replicated the bylaws were also contained in their purchase contracts, and those were held valid as contractual provisions, and so they were bound by the management scheme. And on appeal, that was the only part of the case that went on appeal, and so the Court of Appeal of the Cayman Islands didn't have to consider the impact of the strata title law on the bylaws. They were only concerned with its contractual enforcement. My Lord, then I would wish to take your Lordship to the Byrne case, which is argued against us. That is at tab 21 of volume 2. This is the Western Australia Court of Appeal.
Yes?
The bylaw is at page 1410. Subject to the Schedule 1 bylaw, 16, a proprietor of a residential lot may only use his lot as a residence. And then, notwithstanding bylaw 1, a proprietor of a residential lot may grant occupancy rights in respect of his lot to residential tenants. Well, I regret to say that I haven't been able to discover what the Schedule 1 bylaw 16 was, because it was amended out of the Act in 1995, and the copy of the Act that we have is in its current form. It's no longer there. But it can't have had any impact on this case because nobody refers to it. slightly odd argument put for Mr. Byrne, which appears at page 1419, at paragraph 42, where it said that Mr. Byrne's senior counsel submits the case is solely about bylaw 16. He doesn't challenge the validity of it. And then what he submits in underground 1 at page 1421, he says in paragraph 52 that Order 2 of the Tribunal's orders purports to restrict devolution of lots for a particular use, including devolution by way of a lease for short-stay accommodation. He contends that such rights, that is the right, I think, to lease for short-stay accommodation, are preserved by Section 42(3) of the Strata Titles Act from restriction by any bylaw.
Where's Section 42(3)?
My Lord, it's in, my learned friend assists me by saying it's in volume 1, page 904.
906.
Yeah, starts at 905, I think. Yes.
My Lord, I recall now, it's not in the bundle because of the legislation having changed. I obtained it by downloading, but it hasn't been reproduced. It is in substance in the same form as Section 24.
So what are we talking about now? We've got the Section 42(3) of the 1985 Strata Titles Act in Volume 1. We've got the whole of the Strata Titles Act. Page 906.
Yes, I apologise. There it is. Yeah, okay. So it's in very similar terms to Section 24, except it specifies bylaw amendment or repeal of a bylaw.
Yeah.
My Lord, then moving on in the judgment to page 1445,
Yes.
he reaches the construction of paragraph 151 that what 16.1 and 16.2.1, which we looked at a moment ago, means is that a lot may only be occupied by persons who use the lot as their settled or usual abode. And he goes on to say, the judgment goes on to say this: whilst proof of permanency of abode or extended or substantial occupation of a place may be evidence of a settled or usual abode, in our view, the word residence in this context more accurately denotes a settled or usual abode, Whether someone is occupying a lot for use as their settled or usual abode will, generally speaking, be a question of fact. On the other hand, some uses will necessarily fall outside the phrase use his lot as a residence. A lot occupied by persons who merely use the lot as tourist accommodation or as accommodation for holidays or other breaks away from their settled or usual abode is not being occupied by persons who use the lot as a residence within the meaning of bylaw 16. So what he's saying there is second homes are out. Now, in our respectful submission, looking at the Pinnacle in its context, that's clearly not the same position. And he goes on to say this, and he's here drawing the distinction between use and duration. Occupation, say, for less than 3 months within a 12-month period, being the yardstick apparently applied by the tribunal, might well be evidence that the lot is not being occupied by persons using it as their settled or usual abode. But the word residence doesn't itself import a fixed period of occupation. The prohibition in bylaw 16 is not on periods of occupation, but on use. Thus, for example, if a person had emigrated or moved from another state to Perth and were granted occupancy rights under an occupancy agreement pursuant to bylaw 16.2.1 for 2 or 3 months as a place of residence while they looked to purchase a property, they would prima facie be using the lot as their settled or usual abode in Perth for that time. Someone from interstate or overseas occupying a lot for a limited period to work or study in Perth might or might not, depending on the circumstances, be occupying the lot as their settled or usual abode. And he also says at 153 that the word uses lot as a residence is significant. It means to employ for some purpose. You'd be in breach if you left the lot vacant. And then the final passage I take your lordship to is at 1451, 172. Under ground 3, he says, as noted earlier, Order 2 of the Tribunal's orders operates to preclude Mr. Byrne from using his lot for occupation by any person for less than 3 months in any 12-month period, and is sufficiently broad to preclude Mr. Byrne from leasing or licensing his lot for occupation by any person as his or her residence for such a period. For the reasons given earlier, and as I understand it, those are the passages I've referred to, Order 2 reflects a misunderstanding of bylaw 16 properly construed. And so that part of the bylaw was set aside, the tribunal's order was set aside. And so what we draw from that is this. Under Byrne, the court is careful to distinguish between restricting duration and restricting use. Byrne, like Dunlop, was a case of restricting use because it was the quality of the person staying there, the quality of the occupation that mattered, not the period. As was emphasised, that it could be a permanent residence if you're newly arrived and looking for somewhere to buy, or you're there for a limited period. And likewise, I suppose one could say that if you were on sabbatical or taking an extended career break, you might occupy a short stay unit for a very long time and still be using it for resort use, if that was the permitted user. So in our respectful submission, Byrne, far from being adverse to the appellant's case, supports it, because the part of the tribunal's order that was struck down was the duration restriction. A refinement which I needn't, I think, take your lordship to is the fact that in the Byrne case, the original planning use excluded short-term letting. They had actually changed the planning use to allow short-term letting, but that couldn't affect the operation of the bylaw.
But surely the judge's order was only struck down because he had misunderstood the meaning of residential tenants.
Well,
I mean, this is all to do with the construction of what's it mean, and he'd taken one view and made an order on that basis. And the Court of Appeal say, no. It means settled use. And so
Yes.
it's just words, isn't it? Rather than the basic question of why was this provision valid?
Well, Lord, the point in my submission is this, that the misunderstanding which had been made below was confusing duration and use. It was use which the provision, the bylaw was directed to. It was use that the tribunal's decision and order should have been directed to, but they strayed into duration. My Lord, that, I think, completes what I intended to say on the main issue. If I could then turn to the subsidiary issue of the costs position.
Yes.
The learned judge in this case,
Yes. Would this not be more sensibly dealt with after the judgment has been given?
I'm perfectly happy to deal with it. I follow that your lordships have enough to deal with at the moment, and of course it's a question which
Well,
may
it's
not
not simply,
arise.
it's not a question of whether we've had enough or not, but obviously the submissions can be tailored to meet the terms of the judgment, I would have thought. I think that's probably a better way of proceeding.
Yes. Well, then, may I just take instruction?
Yes, of course. Yes, of course.
Lord, then that concludes the remarks I wish to make.
Thank you very
Can I
much.
just clarify one thing? Insofar as we're concerned about what goes on in Queensland, the Noosa close case you referred us to, volume 3, tab 35, page 1622, sets out the provisions of the legislation enforced there. And am I right in seeing, sort of two-thirds down the page, that legislation contains a specific clause saying if a lot may lawfully be used for residential purposes, the bylaws cannot restrict the type of residential use. So one has there not just a restriction on letting, you actually have a restriction on any, well, it says you can't restrict the type of use.
Yes.
And I think looking at some of these adjudicated decisions, it's possible that they're affected by that, which of course doesn't apply in our case.
No, but what he's striking down is in fact the duration restriction.
Well, I see that, but it does seem to me that looking at these other cases, one's got to be awfully careful to, insofar as they help at all, to make sure one understands what the legislation said.
Yes, it's certainly clear that there is discernibly a difference of approach in, say, New South Wales to the effect to be given to planning. In England and Wales, and my understanding is also in the Turks and Caicos Islands, if you're a developer, you have two distinct hurdles to clear. One is any covenant that affects the property. The other is planning. And it doesn't help you to get a planning permission that it will enable you to do what you want if you haven't also got a covenant, if you haven't also cleared the covenant, even if the covenant is actually in favour of the planning authority. But I think in New South Wales, it appears from Dr. Sherry's book that the planning position and the enforceability position are much more closely aligned.
Yes, thank you very much indeed. Mr. Wilson?
My Lord, I don't think I have anything that I can usefully add.
Thank you very much. Mr. Featherstone?
My Lord, thank you. My Lord, I have half an hour before the short adjournment. I wonder if it might be more effective for your lordships to hear my submissions on Byrne, which my learned friend's just taken you to first.
Just as you think. Yep.
It's found the authority in Bundle 2. Tab 21.
Yes.
And, my lords, this, unlike the various tribunal cases your lordships have been taken to, was a decision of the Supreme Court of Western Australia Court of Appeal. It was also given on the 8th of June 2017, so it's a decision which is 5 months old, of Australia's second highest court. It also concerned original bylaws, and as your lordships can see, it was closely argued by senior counsel. So of all the authorities before your lordships, and there are many, this probably comes closest to being of the most assistance. And of course it concerns provisions which are very closely similar to those before your lordships. Can I clear up one possible misapprehension before I get going? There were 2 lots of relevant bylaws in this case, and one sees them set out on page 1410. And the one that was of particular focus of attention was bylaw 16 in the middle of the page, recited in paragraph 18. So that's the one that's similar, headed use of premises, and then ignoring the unhelpful words which neither of us have any idea about. It says a proprietor of a residential lot may only use his lot as a residence. And then in 16.2, notwithstanding bylaw 16.1, a proprietor of a residential lot may grant occupancy rights in respect of his lot to residential tenants. So it has a similar framework to bylaw 7.19 in our case. It starts with a general reference to using as a private, or as a residence in that case, with then a degree of flexibility introduced by the second part of the bylaw. Now, quite apart from that, bylaw 16, there was another one which had been introduced by way of amendment, and that appears at the bottom of the page, headed short-term use. And that said, in this bylaw, the term short-term use means the use of a proprietor's lot for occupancy as short-term, temporary or holiday accommodation for periods of less than 3 months. Now, that was not the bylaw that the court was primarily concerned with, and the reason for that appears in paragraph 20 on the next page, page 1411. The judgment there says the reference to the short-term use bylaw is included to complete the factual narration, but it has no significance for the disposition of the appeal. At the hearing of the appeal before the primary judge, it was not in dispute that Mr. Byrne had applied for an order, not disputed by the Strata company, declaring that the short-term use bylaw was invalid, effectively on the grounds that it had not been passed pursuant to the requisite resolution. The tribunal had made an order to that effect. So, my lords, that simply wasn't, as it were, up for discussion. It had already been conceded away that there was a virus problem with the short-term use bylaw. It was included, as the judgment says, to complete the factual narration. And it was also quite useful because the 3-month limit introduced relevantly the extent to which one can look at, period, when one considers the extent to which the use is as a residence. But beyond that, that bylaw had no role to play. Now, my lords, if I can go through the judgment in slightly more detail than my learned friend, but bearing in mind the lordships won't be particularly constrained even by as high an authority as this, I'd like to go next, please, to paragraph 68 on page 1426. So right at the top of the page, paragraph 68, says section 4, subsection 2, and the reference there is to the Strata Titles Act 1985. One doesn't need to go to that because it's then recited. Provides that where a strata plan is registered, any number of lots in the plan may devolve or be transferred, leased, mortgaged, or otherwise dealt with in the same manner and form as land held under the provisions of the Transfer of Land Act. So broadly similar to the legislation in the Turks and Caicos. One can then go to the top of the next page, in paragraph 74. As will be noted later, bylaws may be made which, amongst other things, restrict the use of lots and any common property, providing they are not inconsistent with the Strata Titles Act. So same as here. Section 6 of the Strata Titles Act also deals directly with restrictions on use, in that it provides for restrictions to be placed on the use to which the parcel or part of the parcel may be put. And skipping then down to the bottom of the page, paragraph 80, it recites section 42(1) of the Strata Titles Act in Western Australia, which is very similar to section 20, subsection 1 in the Turks and Caicos. A strata company may make bylaws not inconsistent with this act for, and then C is relevant, other matters relating to the management, control, use and enjoyment of the lots and any common property. So that's the legislation. And then going to paragraph 85 on the next page, right at the bottom, judgment goes on, whilst by virtue of section 42(1)(c, that's the one I just read, bylaws may be made not inconsistently with the Strata Titles Act relating to the management, control, use and enjoyment of the lots and any common property, section 42(3) places a limit on the operation of bylaws it provides. And here we have the direct equivalent of section 20 sub 4 in the Strata Titles Ordinance in the Turks and Caicos. No bylaw, amendment or repeal of a bylaw is capable of operating so as to prohibit or restrict the devolution of lots or any transfer, lease, mortgage or other dealing therewith, and so on. Skip the next paragraph. 87 then says the word lease in section 42(3) and leased and so on is not defined, but would also prima facie be given its technical legal meaning of the grant of the right to the exclusive possession of land for a term less than that of the grantor. A lease may be granted for a determinate period, however short. And then on the page 1431, paragraph 96, the bylaws under Schedule 1 and Schedule 2 indicate that obligations in the bylaws may be imposed directly on residents as well as proprietors and occupiers, including in relation to their visitors. A resident, as well as a proprietor and an occupier, is also bound by a restrictive use of a parcel or part of the land in the registered strata plan, that's section 6(2). Over leaf, my lords, page 1433, paragraph 103, under the heading resident, and from now on I'll pick out bits from the judgment, but this general section of the judgment onwards, in some detail, is really very relevant. The reason, I should say, my lords, why the focus is on resident is because the common theme in the concept of residence, which their lordships were dealing with, was that it implied or brought in the concept of a settled abode, not something transient. So this is where this comes in. Paragraph 103, the words other resident of a lot in the phrase the proprietors and any mortgagee in possession or occupier or other resident of a lot are evidently words of expansion. They denote a person who is not the proprietor, a mortgagee in possession or occupier, but who is otherwise a resident of the lot. At least generally speaking, a person may be an occupier but not a resident. The word other does not carry the implication that all or any of the preceding persons mentioned are merely, in effect, illustrations of a genus of resident. And they quote from the judge. And I skip to paragraph 105, a reference to the case of Miller, where Chief Justice Latham observed, I should have thought that there was no doubt that a man resided where he lived. I do not think that there is any interpretation of the word reside by the courts which makes it impossible to apply the ordinary meaning of the word reside in the present case. There's then a reference to the decision of Viscount Cave, Lord Chancellor Levine. The word reside is a familiar English word and is defined in the Oxford English Dictionary as meaning to dwell permanently or for a considerable time, to have one's settled or usual abode, to live in or at a particular place. And then over leaf, my lords, page 1434, paragraph 107, there's a reference back to the case of Marana, referred to by the tribunal, where the full court of the federal court considered that the word residence usually connotes permanent or at least extended occupation. There's more of the same in paragraph 108, a reference to another decision of the Court of Appeal, where reside is defined as including having one's abode in a place for a time. And then the law is brought rather closer to home on page 1435 with a reference to, in paragraph 110, to some observations by Lord Denning in Fox and Stirk, to the effect that a guest who comes for the weekend is not resident, a short-stay visitor is not resident, and Lord Justice Widgery in Fox, to the same effect, residence involves some assumption of permanence, some degree of continuity, some expectation of continuity. I'll read on to 111, if I may. In the context of the obligations imposed and entitlements conferred on a resident in the Strata Titles Act, the word resident and the phrase resident of a lot implies some degree of continuity of living at the lot. It would include at least someone who is making the lot his or her settled or usual abode. On the other hand, the word resident would ordinarily not include, for example, a guest of the occupier or proprietor, or a visitor of the occupier or proprietor who may stay for a few days. That conclusion tends to be confirmed by, and there's a reference to a Western Australian Law Reform Commission report, although it would be undesirable to limit a proprietor's power to lease his lot, to permit occupancy of it, or to allow others to reside in it. The Commission considers that tenants, occupiers and residents should be bound to comply with the bylaws of the strata scheme. Such an extension would result, for example, in a tenant, subtenant or purchaser in possession under an agreement for sale of a lot being bound to comply with the bylaws. Members of a proprietor's or tenant's family residing in the lot would also be bound, as would those living in the lot to the proprietor or tenant. However, a person staying in the lot on a temporary basis, such as a weekend visitor, would not be. My Lords, then over the page to, we find the new heading now, use. Paragraph 113, as noted earlier, the use of a registered strata lot may be affected by a compliant endorsement on the registered strata plan, and that's not relevant. 114, Section 6A recognises that a limitation on use under Section 6 may include a limitation on the nature of the occupancy of a lot, and that picks up nicely my Lord Carnworth's point about Noosa Close and the legislation in that case. Then 116, halfway down the page, under Section 42(1)(c) of the Strata Titles Act, bylaws may be made not inconsistent with the Act relating to the management, control, use and enjoyment of a lot. Those words, singularly and collectively, are words of considerable breadth. The first two lines of the quotation on paragraph of 117 are relevant. The starting point is that it is trite that bylaws frequently interfere with the property rights of the owner of a lot. And then, my Lords, if I go to the top of page 1437, which is a quotation from the judgment in Babson, while a restriction on use might limit the number of potential transferees or lessees, I do not think it can be regarded as a restriction on transfer or leasing or on any of the other transactions mentioned. And in the same vein, but skipping forwards now to page 1443, paragraph 142 at the bottom, turning now to the proper construction of the bylaw, the judgment says, insofar as bylaw 16.1 refers to a residential lot, it must be taken to be referring to each of the 113 lots in the residential apartment development recorded on the strata plan. It's difficult to accept Mr. Burns' contention that the purpose of the word residential in bylaw 16 is to distinguish between residential and non-residential lots, such as commercial or industrial lots. And then to the next paragraph on page 1444, 143 at the top. I'll just read the first couple of lines of this paragraph. Bylaw 16.1 is framed in terms of use. It is addressing the use to which a proprietor may put his or her lot. And then skipping down to near the bottom, about 8 lines up, the sentence beginning accordingly. Accordingly, the words residential tenants in bylaw 16.2.1 are apt to include licensees under a written agreement for occupancy. The word residential means of or relating to a residence. When bylaws 16.1 and 16.2.1 are read together, and with particular reference to the words residence, notwithstanding, and residential, they indicate that a lot may only be used as a residence by the proprietor or by anyone to whom the proprietor grants occupancy rights. In other words, in substance, Bylaw 16.1 and Bylaw 16.2.1 read together mean that a lot may only be occupied by persons who use the lot as a residence. 147, 3 lines in, it may be inferred that the rationale for Bylaw 16 is that occupants for whom their lot is their usual or ordinary residence would more likely preserve the character of the complex as a luxury residential complex than occupants who come and go and whose residence are elsewhere. The next paragraph, in the present context, the phrase use his lot as a residence in Bylaw 16.1 appears objectively to be referring to the use of the lot as one's settled or usual abode. By laws, I can then skip to about the 6th line of paragraph 149, the sentence beginning, for example, someone staying at the lot for a holiday or as a breakaway from their settled or usual abode might arguably be a resident within the meaning of the Strata Titles Act, but a lot used for accommodation of that kind would not involve the use of the lot as a residence within the meaning of Bylaw 16.1. It is unnecessary for the disposition of the appeal to reach a view on whether, for example, the word resident in the provisions of the Strata Titles Act might apply to a holidaymaker staying at the lot. That is because even if the conception of resident in the Strata Titles Act implies some lesser degree of continuity of living at the place than does the word residence in Bylaw 16.1, that would not mean that Bylaw 16.1 operates inconsistently with the Strata Titles Act. On the contrary, bylaws may be made relating to use under section 42.1, and Bylaw 16 is a bylaw relating to use. And then, my lords, over the page, paragraph 151, part of which my learned friend did take your lordships
What are we actually looking for? I mean, you've taken us through a lot of this, but it's mainly concerned with provisions which we're not directly dealing with.
Yes, my lords, I was trying to show how closely similar it was to this case, to give your lordships.
Well, all they're saying is that residence is a concept which has different meanings, but usually implies continuity.
Yes, yes.
That's not our problem.
Well, my lords, I was going to use it to get away from the submissions that have been made by my learned friend to the effect that with the Strata Titles Ordinance in Turks and Caicos, there could be no suggestion that there was something wrong about restricting the use of the lot to particular classes of people.
But he accepts that.
Yes,
No
yes,
dispute.
yes. My lords, I'm probably making heavy weather of it.
No, possibly the critical difference between this case and our case is that that bylaw specifically extended residential use to use by tenants. This one doesn't create quite the same extension because it starts off like 16.1 and then heads off in a very different direction.
Yes, well, my lord, that's a very fair point.
The thing that interested me about this is what a meal they seem to be making, obviously, in Western Australia, but also they seem to have had a law commission report looking at the subject. I don't know whether anyone's checked on that.
Yes, my lord, we have, yes.
We have?
We have, yes, my lord.
Is there anything in the law commission?
It doesn't take matters very much further.
Thank you.
No. And my lord, I wanted to contextualise the reference right at the end of the judgment to which your lordships were taken and the rulings that were made, and to remove from your lordships' heads the notion that it was impermissible to have any reference at all to the period of any particular dealing. That's not what the Court of Appeal was saying in this case. Having disposed of that short-term bylaw, what the Court of Appeal didn't want to do was to try and clothe the meaning of residence with reference to any particular period, because they said, well, that obviously depends on the facts. Now, in our case, what we have in the first part of the bylaw, in 7.19, is a restriction to use as a residence, and the words guests or visitors don't really take the matter very much forward. But I do gain support in my submission from Byrne to the effect that once we find the words use as a residence, we know that that means use for a settled period of time. It doesn't mean something transient. The second sentence of the bylaw, and it might help your lordships to have it open in front of them. It's page 206 of the record.
Which page, please? Did you say 206?
I think it's 206, my lords, but the bylaws are.
2145.
Yes, it's page 214.
Yes.
So, my lords, in relation to the first sentence, not use or permit his residential strata lot to be used other than as a private residence of the proprietor or for accommodation of the proprietor's guests and visitors, I say that Byrne is interesting and supportive in the light that it casts on the meaning of the expression private residence, although Byrne doesn't use the word private. But the focus of that first sentence of the bylaw is not on transient occupiers, it's on the proprietor using as his own residence. One brings in all the concepts to which I've referred in Byrne. The second sentence then, notwithstanding the foregoing, is not imposing a limit, it's relieving the harshness of the first sentence. So what it's doing is saying, well, although the first sentence of the bylaw says you can only use for yourself, your guests or visitors, in fact, you can also rent out in a way that wouldn't involve use as a private residence. But in those circumstances, it should be for not less than a month. So it's not imposing a limit, it's relieving the harshness of the first sentence, which makes it very plain that you couldn't do that activity.
But if the second sentence wasn't there, do you say that the first sentence, naked and alone, let's forget about going round and round in circles by reference to sub-paragraph 16, would or wouldn't infringe section 24? Because if it confines it to the proprietor and his guests and visitors, and you look at guests and visitors in the way that that phrase was looked at in Byrne, how could you let it at all?
Well, my lord, you couldn't. But that's a matter of use. It's not a restriction on dealing.
Well, yes, but if the restriction of use is only by the proprietor and by people who are visiting him or are his guests while he's there, which is the Byrne understanding of guests and visitors, that would be a complete, albeit indirect, but nonetheless fully effective, block on any kind of letting, wouldn't it?
Well, my lord...
You couldn't let it for 10 years to somebody else.
Well, my lord, I don't say that you couldn't let it for 10 years or 99 years, because then effectively the bylaw would apply to the tenant.
Well, that's not what it says, though, is it?
No, well, my lord, I do say it's harsh, the first sentence, and that's no doubt why the second sentence is there.
But if the first sentence itself on alone, naked and alone, would offend section 24, does that affect your submission about the second sentence just being a relaxation of something which is only a use restriction?
No, my lord, because I don't say that the first sentence does offend against section 20, subsection 4.
Even if?
No, it's purely to do with use. And I understood my learned friend to accept my Lord Kerr's question. What about a restriction saying not to be used other than by the proprietor or his guests for I'll say that again. Not to be used other than by the proprietor or his guests for holiday purposes would be a restriction aimed at use and not at dealing. And that's precisely the same in its effect, my lord, as the first sentence here.
Well, even though it would wholly prevent any letting, because unless you let to yourself, it wouldn't be for use as a residence by the proprietor.
If you took a subtenancy from your lessee.
Yes. Go round in a circle for some tax reason.
But, my lord, that's precisely what it would do. And that would be harsh. It would be really quite unworkable. And it's for that reason that the second sentence is in there.
Which, I mean, your submission is in substance, therefore, that you can have a provision which in practice restricts letting, provided it does so indirectly. In other words, you can have a restriction on use, notwithstanding that restriction is inconsistent with any letting, provided that you don't directly inhibit letting. Is that the submission?
That is my submission. And I understood my learned friend to accept the same point when it was put to him. He was asked by, I think, my Lord Briggs, what is the distinction that you're making here? What is it that explains the difference? I'm sorry, it was Lord Wilson. But what's the distinction you draw if you accept that there can, in certain circumstances, be a provision inhibiting leasing to particular people? What's the difference? And learned friends said, well, it's the difference between direct and indirect effect. So we're ad idem on this point, my lord. I say that all that the first sentence of the paragraph 9 does in the bylaws is target use. It's just saying you can only use as a residence, you, the proprietor. And if that stood by itself, that would be awfully harsh. And I agree with the learned friend that it's doubtful that the strata lots would be particularly marketable in those circumstances. And that's why the draftsman has introduced the second sentence.
Why?
You've got to read the two together.
What is there in the second sentence that actually permits the tenant to use it himself for residential purposes? Because, I mean, strictly what it says is he can rent it out, but the restriction on use, I mean, if you're taking that very strict difference between restriction on use and renting out, would still apply. The tenant would still be stuck with the restriction that it can only be used by the proprietor. And the proprietor is defined as the owner or owners of the strata lots. That's the original owner.
Well, my lord, the words notwithstanding the foregoing means it may be contrary to what's set out in the first sentence. The proprietor may rent out. That obviously doesn't mean to himself.
I mean, the problem is it's not very clearly drafted. Something's got to give, and the question
Yes.
is
I mean,
what?
isn't the intention of the second sentence, albeit not very well drafted, designed to achieve something like 16 point, whatever it was, 2.1 of the Byrne regime, namely to bring residential use by tenants within the permitted purview of the use restriction, subject to an express time restriction, duration restriction?
Well, my lord, no. In my respectful submission, that stands the drafting on its head. What it does is say you can only use it as a residence for yourself. However, second sentence, you can rent out to others, but not for less than a month.
But can they use it as a residence for themselves if you let it to them for 10 years, for themselves?
Yes.
So it brings the tenant on board within the
yes.
the use restriction.
Oh, yes, it does.
And is there anything to stop them using it for other purposes than residential?
Well, it's a residential strata lot.
There is in 716, but not in 79.
Yes. Well, 16 just comes back in with the circularity. So my Lord Carnworth's question is, what if you have a proprietor who rents out for a period longer than a month to somebody who uses it for repairing motorbikes, that sort of thing? Well, my Lord, I don't pretend the drafting is foolproof, and it may be that could be done. It would be really quite difficult to pick somewhere gorgeous like Providenciales and start repairing motorbikes instead of having a holiday for a month or more. But yes, if that were done, then I suspect that the proprietors would get together and draft an amendment to the strata plan with more bylaws, but I'm not aware it's been done. But no, I don't pretend any of this is foolproof. What I do say is that you have to read the first and second sentences together, with the second mitigating the hardship of the first. And that's entirely consistent with the position in Byrne. My lords, that's all I was going to say about Byrne. I have some more general submissions to make, and I don't know whether I should go ahead with them now, or...
How long will they take, Mr.
Well, I can take it really very shortly, but I would have thought 15 minutes, that sort of thing.
Well, we'll rise now then. We'll sit again, 2 o'clock.